Good afternoon, everybody. I suspect that very kind introduction is attributable in no small part to the fact that I was the junior judge in the T case, to which I'll come in a moment. But at any rate, let me start with a few words by way of introduction. Juries are required every day to weigh pieces of evidence and to decide whether the only reasonable explanation for them taken together is that the accused is guilty, or whether there is a reasonable possibility that he's not. They may, for example, be required to consider how likely it is that one extraordinary coincidence has been followed by another. Doesn't it make sense in these circumstances, as the great jurist Professor Glanville Williams suggested in 1979, that jurors should, so far as possible, be helped in estimating the relevant probabilities by hearing expert evidence? He recognized there'd be dangers in such evidence, and the risks of drawing false conclusions would have to be brought out properly. But, he continued, it's better that the implications of the evidence should be analyzed in court and the risks quantified if possible, than that it should simply be left to the jury for their gut reaction. And as Professor Philip David has observed, common sense has proved to be a lamentably poor guide in addressing the statistical issues to which these cases have given rise. Well, these are powerful points, and yet the relationship between the courts and probabilistic reasoning has not been an easy one. In the course of the next 30 minutes or so, I will try and give you a personal perspective as to why that has been so. I shall also try and outline the way the court's approach to probability theory has developed incrementally on a case-by-case basis and has been heavily dependent upon the particular area of forensic science in issue and the quality and the transparency of the evidence before it. Overall, I believe the approach has been logical and pragmatic, and that far from excluding evidence based upon probability theory, the courts have accepted it where it has been relevant and proportionate, where the methodology underpinning it has been clear and transparent, and where it hasn't trespassed into those areas which remain properly the province of the jury. So with that introduction, let me try and dispel some of the concerns that those working in this field have expressed about the court's attitude to statistics and probability, particularly after the T decision. I'll say a little bit about the use of databases, which are not comprehensive, evaluative opinions based solely upon experience, verbal scales, and likelihood ratios. Let me start with databases. Is it permissible for a forensic expert to base his or her opinion in part upon a database in which the results of other workers are embodied? Well, the answer is yes, and the Court of Appeal explained that in Abaddon as long ago as 1983. The case concerned a robbery allegedly carried out by a gang led by Mr. Abaddon. The principal evidence against him was that a pair of his shoes were found to have fragments of glass embedded in them, which, so the prosecution contended, came from a broken window at the premises where the crime was committed. Well, to establish this case, the prosecution called an expert who explained that the fragments of glass in the shoes and the glass from the broken window had an identical refractive index. He was then asked about the frequency with which that refractive index was found to occur, and he explained that the Home Office had collected statistics of the refractive index of broken glass analysed in forensic laboratories over a number of years. On interrogation of the database, he found that the particular refractive index only occurred in 4% of cases, and he went on to express the view that, given this percentage, his study provided very strong evidence that the glass from the shoes was in fact the same as the glass from the window. In fact, he said, it originated from the window. Well, the defense, perhaps not surprisingly, called a witness who explained that 4% of all the glass manufactured amounted to a very substantial amount of glass indeed. But the point taken on appeal was not based upon the prosecutor's fallacy, but rather that the expert had given inadmissible hearsay evidence. And this contention was forcefully rejected by the Court of Appeal. They held that an expert must be entitled to draw upon material produced by others in the field Indeed, the court continued, relative probabilities must frequently be an important factor in the evaluation of any expert opinion, and where any reliable statistical material is available which bears upon the question, it is part of the duty of the expert to take it into account. Next, evaluative opinions based upon the expert's experience and the use of verbal scales. An expert may, in an appropriate case, base his or her opinion simply upon experience and may express that opinion using a sliding scale of propositions. This was established in the Dean Atkins case, the facial mapping case, in which the expert compared photographs of the robbers seen at the scene with photographs of Mr. Atkins taken using a technique of which he had some 20 years' experience. Having done so, he expressed his opinion by reference to a verbal scale that the similarities which had identified lent support, or perhaps strong support, to the proposition that the man at the scene was Mr. Atkins. On appeal, it was contended on behalf of Mr. Atkins that the expert could properly explain the techniques he'd used and demonstrate the similarities or dissimilarities between the images. However, so the argument went, in the absence of a database, cataloguing the number of persons with particular features or measurements meant there was no justification for his expression of support for the proposition that the man in the photograph was Mr. Atkins. Well, Lord Justice Hughes, giving the judgment of the court, rejected that contention. He explained that the fact that the conclusion was not based upon a statistical database needed to be made crystal clear, but it did not preclude the expression of an opinion beyond rehearsing his examination of the photographs. An expert with great experience could properly form a judgment as to the significance of what he'd found, and the jury were entitled to be informed of that assessment. Well, in each of these cases, the evidence relied upon was supportive of the case advanced by the prosecution and much less supportive of the case advanced by the defendant. Put another way, the chance of that evidence being found was much greater if the accused had committed the offence than if he had not. And this way of thinking about relative likelihoods also underpinned the next two decisions I'd like briefly to discuss. But they're also illustrations of how easily statistical evidence can be and has been presented in a very misleading way. The first concerned the conviction of Barry George, which was referred back to the Court of Appeal by the Criminal Cases Review Commission in 2007. Now, you'll remember that Barry George was convicted of the murder of Jill Dando, and his original appeal against that conviction was dismissed. Miss Dando was killed by a single gunshot to the head, and a part of the evidence upon which the prosecution relied was the similarity between the firearm discharge residue found in Miss Dando's wound and a single particle of the FDR found in the pocket of Barry George's coat. Well, on the hearing of the reference, the Lord Chief Justice, Lord Phillips, presided. 3 experts gave evidence, 2 for the appellant, Mr. George, and 1 for the Crown. And the evidence that they each gave was entirely consistent with the evidence of the others. And it amounted to this. It was necessary to balance the likelihood that the particle of FDR came from a gun fired by Mr. George and the likelihood that it came from some other source. Both were unlikely, but both were possible. It couldn't be said that one was more likely than the other. In the circumstances, the presence of this particular particle in the coat provided no support for the proposition that the person wearing the coat had actually fired the gun, and so the verdict was unsafe and the conviction was quashed. Sally Clark. We've heard a little bit about Sally Clark today from Paul Roberts. Sally Clark was convicted in 1999 of the murder of her 2 baby sons, first Christopher and then Harry. Her appeal was dismissed in October 2000. The case was referred back to the Court of Appeal by the Criminal Cases Review Commission in the light of new evidence which suggested that Harry may not have been murdered but may have died from natural causes. Well, the appeal was allowed and the conviction quashed, But the case is relevant to this discussion in the light of the statistical evidence that the Crown adduced at the trial as to the likelihood of there being 2 sudden infant death syndrome deaths in one family. Well, the famous evidence given by Professor Meadow was that a figure of 1 in 8,500 odd reflected the risk of there being a single SIDS death within one family, such as that of the Clarks, and that the risk of there being 2 such deaths was that figure squared. That is to say, a chance of about 1 in 73 million. Well, there were 2 main problems with the evidence. First, it was not permissible to square the probability for a single death unless it was shown that the 2 events were truly independent. This was never shown and is, in any event, implausible. The 2 children had the same parents and were brought up in the same environment. The second is more often overlooked, and it is this. No consideration was given to the likelihood of the alternative hypothesis, that is to say that Sally Clark had murdered her 2 children. Indeed, the probability that both infants would be murdered would seem, on the face of it, to be at least as relevant as the probability that both would die from SIDS. Supposing the probability of there being 2 infant murders was also 1 in 73 million, then it could be seen straight away that one would be no more likely than the other. Well, as it was, the appeal was allowed on other grounds, but the Court of Appeal did observe that this evidence should never have been before the jury. Well, drawing the threads together, it seems to me, first of all, that it is permissible to use likelihood ratios in an appropriate case. Indeed, it may be essential. Secondly, it is permissible to use a database which is not comprehensive, provided, I would suggest, that it is in fact representative. And third, likelihood ratios and an opinion about them may be informed by personal opinion. Well, as we've seen, a likelihood ratio compares the likelihood of the evidence, say a footprint, given the hypothesis contended for by the prosecution on the one hand, and the hypothesis contended for by the defense on the other. It does not provide a likelihood of the validity of either hypothesis, or put colloquially, the probability that the defendant is actually guilty. Well, I recognize that a logically correct way to incorporate a likelihood ratio into an assessment of probability of the hypothesis is to use Bayes' theorem, an approach which incorporates into the assessment an estimation of the prior probability of the hypothesis itself. Now, though logically attractive, the theorem has not found favour with the courts, partly for pragmatic reasons. Evidently, jurors and judges have had great difficulty in understanding it, but also because it's been perceived to trespass into areas which are properly the province of the jury alone, and require an assessment which does not lend itself to statistical analysis. There are 3 cases which I think are absolutely key in this area. The first is the appeal against the first trial and conviction of Dennis Adams in 1996, a case which was introduced by David Lagnado this morning. Mr. Adams was convicted of rape at the Central Criminal Court, and the prosecution case relied upon expert evidence relating to the DNA profile obtained from semen on a vaginal swab taken from the victim. It was contended that a randomly chosen man matching the DNA profile taken from the semen was 1 in about 200 million. Well, the defense team were permitted to leave evidence of the effect of the application of Bayes' theorem to all of the evidence in the case. That is to say, as was mentioned this morning, not just the DNA evidence, but also evidence of a failure by the victim to pick out Mr. Adams on an identification parade, evidence of the victim in the course of the committal proceedings that Mr. Adams did not look like the man who'd attacked her, and alibi evidence given both by Mr. Adams and by his girlfriend. Well, I think it's pretty clear from the Court of Appeal judgment that the trial judge did not himself understand Bayes' theorem and presented a rather confused picture of it to the jury in the course of his summing up. And the jury, as I've said, returned a guilty verdict. Well, on appeal, it was contended on behalf of Mr. Adams that the jury were misdirected about the proper application of Bayes' theorem. Well, the Court of Appeal agreed that the jury had been misdirected, but not quite in the way for which the defence team contended. The court held that the judge had unduly focused his attention and directions on Bayes' theorem and ought to have indicated to the jury the more common sense and basic ways in which it would have been open to them to consider the relative weight of the DNA evidence. If they were confused and failed properly to understand Bayes, as seemed very likely, then they were left without any adequate guidance. Well, the appeal was allowed and the case remitted for trial. But the court also took the opportunity to make a number of important points concerning the use of Bayes' theorem, about which it clearly had the gravest doubts. And these points are fundamental, I think, in considering the way forward. First, it appeared to trespass on an area exclusively within the province of the jury, namely the way in which they evaluate the relationship between one piece of evidence and another. Secondly, the theorem could only work by giving to each separate piece of evidence a likelihood ratio. These ratios were a matter of judgment, but this might be concealed by the apparently objective numerals used. Third, the theorem imposed far too rigid an approach to the type of evidence that a jury has to assess. So, for example, identification evidence may have to be assessed at least in part in the light of the strength of the chain of evidence of which it forms a part. Fourthly, jurors might differ not only on how cogent or persuasive they found a particular piece of evidence to be, but also on the question of what likelihood ratio should be attached to it. In the result, you might find that jurors wish to select different numerical figures, even if they're broadly agreed about the weight to be attached to the piece of evidence in issue. And finally, to introduce Bayes' theorem, or a similar method, would plunge the jury into inappropriate and unnecessary realms of theory, deflecting them from their proper task. Well, the issue was revisited again just a few months later in the case of Doheny. And there, the Court of Appeal, with Lord Justice Phillips presiding, gave important guidance about the procedures to be adopted when DNA evidence is adduced. But for present purposes, I think the following points are particularly relevant. The Court explained that it's perfectly proper to explain the nature of the match and, on the basis of statistical data, give the jury the random occurrence ratio, the chance that a person with matching DNA characteristics will be found in the population at large. It may also be proper, provided the relevant data are available, to say how many people with matching characteristics are likely to be found in the United Kingdom, or perhaps a more limited subgroup. And this will clearly help to dispel any possibility of the prosecutor's fallacy. But this will usually be the limit of the evidence that the expert can usefully give. The expert should not express an opinion on the likelihood or probability that the relevant sample actually came from the defendant. And the court strongly endorsed the deprecation of the use of Bayes' theorem in the Dennis Adams case. Well, just over 1 year later, and following his retrial and conviction, Dennis Adams appealed once again to the Court of Appeal, with, on this occasion, Lord Bingham, the Lord Chief Justice, presiding. And at the trial, the Crown relied, as it had before, solely upon the DNA evidence derived from the vaginal swab taken from the victim. The defence again invited the jury to pay attention to Bayes' evidence in relation to the non-DNA evidence with a view to calculating the overall probability of guilt. A statistician explained Bayes' theorem in detail in writing and in the course of his oral evidence, and he introduced the jury to a questionnaire which he prepared which related to it. However, the judge did not direct the jury fully and invited them to apply their common sense in the light of the first appeal, no doubt. Well, on appeal to the Court of Appeal, counsel for Mr. Adams argued that the prosecution should not have been allowed to adduce statistical evidence regarding the random occurrence ratio unless the defence were, for their part, allowed to rely upon Bayesian evidence and the jury were fully directed about it. Well, Lord Bingham, in dismissing the appeal, said this: "We regard the reliance on evidence of this kind in such cases as a recipe for confusion, misunderstanding and misjudgment, possibly even among counsel, but very probably among judges, and, as we conclude, almost certainly among jurors. And a little later he expressed the clear opinion that expert evidence should not be admitted to induce jurors to attach mathematical values to probabilities arising from non-scientific evidence. Well, in the current state of the law in England and Wales, it is therefore not permissible to use Bayes' theorem in relation to different pieces of non-scientific evidence with a view to assessing the overall probability of guilt. It's proved to be too difficult and too complicated for judges and jurors to understand. It may give jurors a false degree of confidence in the result, and it trespasses into areas which are properly for them alone. An open question is whether it may be used in relation to different aspects of expert scientific evidence, and this is a matter on which members of the audience, I'm sure, have their own views. Well, that brings me to the T appeal, in which, as I said at the outset, I sat as the junior of the three judges. I should say straight away that the expert evidence in that case involved the use of Bayesian reasoning and not Bayes' theorem. By way of background, the expert from the FSS attended at the scene of a murder and recovered evidence of footwear marks, which he later compared to the soles of some trainers recovered from T's house. Well, the expert prepared a report for the trial, and he explained in that report that a likelihood ratio approach had been adopted. In other words, he assessed the likelihood of obtaining that correspondence if the trainer in question had made the mark, divided by the likelihood of obtaining that correspondence if the trainer had not made the mark. The expert then explained the results of his comparison. The sole pattern and the size of the trainers matched the marks at the crime scene, but the pattern was very common. Secondly, the wear on the trainers was greater than that made by the trainers which made the marks at the crime scene, but this, he said, could have been the result of additional wear in the intervening period. And thirdly, some of the marks at the crime scene suggested that the trainers which had made them had suffered damage, but no such damage could be seen on the appellant's trainers. There were, he said, possible explanations which would mean that this discrepancy did not exclude the possibility that the appellant's trainers had made the marks. Well, one might think that's not very promising. Nevertheless, the expert concluded that it was somewhat unlikely that the observed correspondence was merely a coincidence, and that that correspondence provided a moderate degree of scientific evidence to support the view that the appellant's trainers made the marks. Well, it emerged in the course of the appeal that the expert had in fact arrived at the likelihood ratio for each of the features of pattern, size, wear, and damage, that he then multiplied these together to arrive at an overall likelihood ratio, and that he then translated that into a verbal equivalent using a scale in which a likelihood ratio of 1 to 10 equated to weak or limited support, 10 to 100 to moderate support, 100 to 1,000 to moderately strong support, and so on. None of that had been disclosed by him in his report. The figure of 100 that he ultimately arrived at, which translated into moderate support, arose from his calculation as modified by him in the light of his own experience. A number of other matters also emerged. First, the expert had used an internal database of the FSS to examine the frequency of the pattern. This database comprised only a tiny fraction of the shoes sold in any one year, but nevertheless revealed that the pattern was one of those most frequently encountered. As for the frequency of size, the expert used a trade association database which suggested that 3% of the shoes in the population were of the relevant size, which was a size 11. As for damage, and despite the discrepancy between the trainers and the marks, it seemed that the expert used a likelihood ratio of 1 in his overall calculation. Well, the Court of Appeal also had the benefit of hearing expert evidence from a number of other witnesses about how widespread the practice of using Bayesian theory and likelihood ratios had become. Certainly they were widely used in the FSS, but it is not without interest, I think, that Mr. Lewis, the principal scientist at the FSS responsible for case assessment and interpretation, explained that numbers were often not put into reports because there was a concern about the accuracy and robustness of the data which underpinned them. Further, in many countries, it became clear the practice was different from that of the FSS. For example, in the United States, a distinction was drawn between class characteristics, such as pattern and size, which were often regarded as being of little or no value, and identifying characteristics such as objects attached to the sole of the shoe or cuts, which could form the basis of a more positive identification. Well, against that background, the Court of Appeal expressed the following general conclusions about footwear analyses, and I emphasize it was about footwear analyses. First, the examiner can explain the degree of match in terms of pattern, size, degree of wear, and so forth, and can express an opinion on the basis of such class characteristics as to whether or not a particular shoe could or could not have made the mark in issue. The examiner can also, in an appropriate case, express a more definite evaluative opinion, and can do so on the basis of, for example, unusual features, such as unusual sizes or unusual patterns. But what the Court of Appeal said an expert in this field cannot do is perform the kind of mathematical analysis which the expert had carried out in this case, because there was simply no sufficiently reliable basis for that to be done. Any attempt to carry out such an assessment was likely to give a false degree of confidence in that expert's conclusion. And secondly, the Court emphasized it's absolutely essential that any expert report is completely transparent, and the expert must explain the reasoning and the basis for any conclusion. Well, the Court concluded that the conviction in this particular case was not safe and had to be set aside. And the reasoning, I think, can be distilled into this. The calculations used by the expert had not been put before the jury. The process by which the evidence was adduced lacked transparency. The use of the likelihood ratios in the way they had been used, without there being an opportunity to debate that use in open court, was contrary to the principles of open justice. And finally, the conclusion reached by the expert could not be regarded as logical, balanced, or robust when the data upon which it was founded was so uncertain. Well, as I've mentioned, this decision has given rise to a good deal of comment. Fears have been expressed that it may preclude the use of likelihood ratios or the informing of likelihood ratios by personal experience. But it seems to me that these fears are not validly held and have been overstated, and that this decision must be seen in context. It is, as I've said, expressly limited to footwear analyses, and it concerns the application of Bayesian reasoning to a combination of class characteristics, the probative value of which was highly debatable. Indeed, the application of the expert's full formula to the data in fact put before the jury would have produced an overall likelihood ratio of over 26,000, amounting to very strong support, a result that the expert did not himself feel able to support. And there was a further problem, I think, with the calibration of the verbal scale, for it emerged that there were very few footwear patterns anywhere which would produce a likelihood ratio of less than 10, that is to say, moderate support for the prosecution case. Indeed, any figure above 1 would provide weak support. In a nutshell, the application of the Bayesian approach to the combination of data relied upon produced a result in which it was not possible to have any degree of confidence. Well, I recognize the importance of probabilistic reasoning in forensic science, but I would like to, if I may, emphasize from a personal viewpoint some of the points made by Paul Roberts. The cases have, I think, exposed some of the pitfalls and limitations of Bayesian reasoning and the use of Bayes' theorem. Going forward, I think it is highly desirable that, so far as possible, the experts in probability theory and forensic science continue their efforts to develop a common understanding about how to evaluate forensic evidence for use in court proceedings, and that they do so in conjunction with the regulator, the judiciary, and the legal professions. Secondly, I think it would be of enormous value for that common understanding to be embodied in a simple and readily accessible form. In other words, a primer, or perhaps a series of primers about the science about which there can be no sensible further dispute. I recognize what Paul Roberts has said about that and what a challenging task it is, But it does seem to me that if such primers can be produced, which eliminate the scope for dispute in court over such things as Bayesian reasoning, likelihood ratios, and even conceivably Bayes' theorem, that is infinitely desirable. Thirdly, forensic scientists must always have firmly in mind that their evidence must not only be logical and balanced, but also fully transparent. There should be absolutely no scope for uncertainty or misunderstanding about the processes of reasoning that they have adopted. And finally, I would urge that efforts continue to promote the better understanding of probability theory by practitioners and the judiciary. I have to say that when the T case came before us, we were not given a great deal of assistance, at least at the outset, about what Bayesian reasoning was, what likelihood ratios were, or what Bayes' theorem was. So I urge that efforts continue to promote the better understanding of probability theory by practitioners in the legal world and the judiciary. And I applaud the efforts of the Royal Statistical Society, the Royal Society, and of course, most recently, this institute. Thank you very much.
Take one or two questions before
Jane Hutton from Warwick Statistics. Of course, you've been talking largely about criminal cases, and I work generally in civil cases. With your discussion, I wondered whether there is some view on courts instructing experts, I don't know whether appeal judges are allowed to request an expert to explain things to them, or what the role of that might be.
The position in the civil jurisdiction is this. The parties can obviously themselves each instruct an expert in any field which is relevant to the issues before the court. The court may direct that they should try and agree a common expert. There should be simply one expert witness giving evidence on the issues which arise. If there are in fact two experts, then they are urged to put their heads together before the trial and to identify the common areas between them and specifically individualize the items which remain in dispute. The court does have power to require an expert witness to be appointed, and what's more, the court does have power to request the assistance of a scientific advisor. And that scientific advisor then would not participate in the decision-making process, but would sit with the judges, or the judge at first instance, and would assist that judge or the judges on appeal to understand the issues which arise, to get the context in which they appear, and hopefully to avoid making a complete botch of the science. But yes, there is a big range of options available.
Is that also possible in criminal cases?
I think that the practitioners who spend most of their time in crime here would be better placed to answer that question than me. But yes, I think there is no reason why, in principle, in a criminal case, the parties cannot each have their expert witness, or that there may be a single joint expert who can deal with matters which arise in the case on a non-contextual basis. But Stephen Owen may have an additional comment on that.
That's right. In crime, you do get experts on each side. You can order them to hot tub.
Mm-hmm.
You can then direct a common statement of issues or agreement. But I think there is a difference in that I've never known any criminal appeal where the court has sought, or certainly criminal trial or criminal appeal, where the court has sought its own expert.
Yes.
I think that would be regarded as, so to speak, going beyond dealing with the adversarial situation that arises.
Yes. Well, I think insofar as any such person was going to deal with issues in dispute, that would be absolutely right, that the party should have an opportunity to question that person. But if it's simply to put the case in context and to explain the science so that the judge understands it, that I think might be a different matter. And certainly that happens in the civil jurisdiction, and I've seen it myself and had the benefit of it too.
Thank you very much.